I'm going to call this meeting of the Planning Board to order. Today is February 18th, 2026, 5 o'clock. If you all will stand and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Everybody have a chance to look at the agenda? I will make a motion to approve tonight's agenda. Could I get a second?
Second.
Thank you, Ed. Any discussion? All in favor, say aye.
Aye.
Opposed? None. You've got minutes from the January 21st meeting in front of you. They're short. I found one little typo, Wes, on line 63. It's got 2 twos instead of 1 there.
Yes, sir.
That was all I found. Anybody else have anything? Okay. I will move to approve the the January 21st, 2026 meeting. Could I get a second on that?
I'll second.
Thank you. Was that Michael or Charlie? Charlie, okay. Thank you, Charlie. Any discussion on those minutes? All in favor of approving my motion and Charlie's second, raise your hand. Say aye.
Aye.
Opposed? None. Okay. Public comment. I think we got to worry about that tonight.
Because there's no public, not because we're ordinarily worried about it.
That's right. Yeah. It's not a concern tonight. Okay. Public comment, none. Old business, none. New business. I'm going to let Wes just briefly describe what that entails.
Yes, sir. Thank you and good evening, Mr. Chairman and members of the board. Tonight is an exciting night. We have a little bit of quasi-judicial training. We have 2 videos, several videos that we purchased from the School of Government that they offered for advisory boards, elected officials, staff, on multiple topics. And I discussed with Chairperson Ward the topics that we have available. And tonight, since we didn't have any other new business to consider currently, we thought it would be a good opportunity to view a couple of these videos. And quasi-judicial procedure and quasi-judicial decisions are on the list tonight. One of them is, I think, a little over 30 minutes, and then the other is less than 30 minutes. So unless y'all have questions, I'm just going to go ahead and get right to it. And if y'all want to come down here and take a seat down here to see the screen from that angle, you're welcome to do so. However, whatever you're more comfortable doing and whatever you can see the screen better. So I believe Jim Joyce, one of the professors at School of Government, I believe he's the faculty member that is doing the training. Y'all may recall that the last training video we did, I think, was 2021. Mm-hmm. Yeah. And he did, I think it was him and Adam Lovelady, but he's doing both of these tonight, I believe. And these are already pre-recorded, I should have said. The last time I think one time we did it, it was live.
Yeah, we Zoomed.
Yeah, in this case, this was pre-recorded, so yeah. There's no interaction with Professor Joyce.
Okay. All right.
So we're going to start with the quasi judicial process. And as y'all will recall, you all are the decision makers in two instances of quasi judicial decisions, variances and appeals, which most of y'all are very familiar with those, but it never hurts to go through this information again.
Wes, that monitor isn't on.
I'm Jim Joyce, faculty member here at the UNC School of Government. In this module, we'll talk about quasi-judicial process, the procedures for making quasi-judicial land use decisions, what the formalities are, and why they are this way. It all starts with due process. When someone is a party in a court of law, our constitutions, state and federal, entitle them to some due process. That just means a fair and reasonable process. Just like people are afforded those rights in a judicial context, we honor people's due process rights in a quasi-judicial context as well. Here's what that means. It means that a party in a quasi-judicial proceeding has a right to clear guiding standards, a notice, an opportunity to be heard at some hearing or tribunal meeting. They have a right to their decision being made by an impartial decision maker based on the evidence in the record. And if they don't like it, they have a right to an appeal. So we're going to talk about each of these due process rights in a little more detail as we go through the process, walk through the process of making a quasi-judicial decision. So let's say local government gets an application in. We need some guidance for how to decide the case, right? We need those clear guiding standards. I want to step back for just a moment to talk about who gets those due process rights, because not everyone in the community has the same right to participate in the quasi-judicial proceeding. Think about, again, we can think by analogy to a judicial proceeding. If there's a trial going on between two different parties, I, as a member of the public, don't have due process rights because it's not my interests that are at stake. So we try to limit certain participation to folks who have a stake in the quasi-judicial decision. Our statutes define that as standing. Someone who has standing has an adequate kind of stake in the game. The statutes define these parties as the ones who have standing. First, the property owner or someone who holds a property interest, like a purchase contract for the piece of property that is at issue, the subject of the variance or special use permit or what have you. Then the applicant, person who's asking for something. There's also another category of folks who have standing. This is a tricky one, and it's actually fairly narrow. Other property owners who would suffer special damages as a result of the quasi-judicial decision that's made, they can also participate as parties. But that range of people who suffer special damages is pretty narrow. It really has to be a unique effect. So if I'm applying for a special use permit to put in a small apartment building on the little lot where my home currently stands, then while, say, people who live next to me would certainly be affected by the result of whether I get my special use permit or not, they're all affected in a similar way. To have special damages, you would have to have a situation like this. I live in the Piedmont region of North Carolina, so of course my house sits on a hill. Let's say I'm seeking a special use permit to put in a small apartment building, and the property owner across the street is downhill from me. So if I alter the way that stormwater flows across my property, or put sediment or other things out there that might go onto their property, now that neighbor is being affected in a way that other neighbors in the area are not. So they would suffer special damages. Think of it this way. We take the general public's concerns and opinions into account when making the legislative decision to set the standards. Right? When we have a use designated as a special use on our zoning ordinance table of uses, then that means we're okay with that use in that area as long as they meet certain conditions. So in deciding those conditions and in voting on the legislative text and table, that's where the general public gets its say. To have standing in this quasi-judicial case, we need something very peculiar to a particular property owner. There is one other party that has standing, but that really comes up largely in the context of an appeal of a quasi-judicial decision. The governing board of that same local government has standing to participate in the quasi-judicial case, and more importantly and more frequently, to appeal the decision of their own board of adjustment. So those are the parties to whom that due process is due. Now let's talk about those clear guiding standards. Right? We had clear guiding standards, notice and an opportunity to be heard, an impartial decision maker, a decision based on the evidence, and a right to an appeal. So what do we mean by clear guiding standards? How clear do they need to be? If you look at the standards that are on this slide, these are not measurable standards or ones where it's easy to say, look at a plan and check a box. If they were those kind of more straightforward standards, we'd make what's called an administrative decision, which is a different process. Here, look at some of these standards. The establishment, maintenance, or operation of the special use will not be detrimental to or endanger the public health, safety, and welfare. The special use will be in harmony with existing development. Skipping down, it will not substantially injure the value of adjoining property. We can't look at a map or a plan and figure out whether these conditions are met or not. What we need is the full facts of the situation and an impartial decision maker who can sift through those facts and apply them to our standards. So to be clear guiding standards for purposes of due process, they just need to kind of direct the board. What is it that I need to be looking for as a board member? If I'm applying these standards, then I need to be thinking about public health, safety, and welfare. I need to be looking at whether there's adequate infrastructure, how it fits into the surrounding area, and what impact it might have on property values. So it's not that precise check the box, measure the setback, but it gives the board something to go on. Here's what we're looking for. Here are the criteria that we're going to apply so that it's not just a wide open, should we grant this special use permit or not? Let's talk about notice and an opportunity to be heard. State law requires that notice be given to the owner of the property, the applicant, and owners of adjacent property. Usually that's mailed out. There are a couple of exceptions for local governments that can send those out electronically, but for the vast majority of North Carolina local governments, those need to be mailed out and there needs to be a sign on the property. Now, this is the minimum notice required by state law. Many of your ordinances will require additional notice. For example, there are a number of local governments throughout the state that require that notice be mailed to the owner, the applicant, and owners of property, say within 100 feet of the subject property. So when looking at the notice requirements for your particular jurisdiction, it's important to look at your ordinance to see if there are additional standards above this minimum that the state law sets. So that's our notice. And since we're giving notice of a hearing, yes, we're going to have an opportunity for the parties with standing to be heard. Now parties that have standing, again, that's the applicant, that's the property owner, that's those folks with that who would suffer that special damage. They can do the things that we would see in the courtroom dramas, right? Cross-examining witnesses, making legal arguments, objecting to submission of certain evidence. Now, it is often the case that a local government board of adjustment will allow, and indeed probably should allow, members of the public to come and provide their own testimony and present their own evidence. A board can allow anyone to present evidence, as we'll see there are standards for that evidence, but someone who is not a party with standing can't act as a party, do this cross-examining and making legal arguments, etc. So we've got our clear guiding standards, our notice, and our opportunity to be heard. Then we move into kind of building on that opportunity to be heard and the hearing itself, right? We've provided notice. Now we're at the evidentiary hearing where we're going to take evidence and the board is going to decide whether to grant this quasi-judicial, approve a quasi-judicial application or not. Now, what you see on your screen is the usual process, what we see most often across the state. This process isn't mandated by state law, but having an opening, an introduction, and then the presentation of evidence, and then time to deliberate, and that final decision help to preserve some of those due process rights to impartial decision makers and evidence-based decisions. Then, of course, we get to appeal afterward if we don't like it. So when talking about an impartial decision maker, here's a handy quote from the North Carolina Court of Appeals from just a few years ago. And they said, in quasi-judicial proceedings, no board or council member should appear to be an advocate for or take an adversarial position to a party. They shouldn't bring in extra or incompetent evidence, and they shouldn't rely on ex parte communications. What we're going to talk about in the next couple of minutes is how we tease that out and avoid those pitfalls in terms of being an impartial decision maker or not. Now, usually at the opening of the hearing, there is an opportunity for us to kind of not just introduce the case, but oftentimes there's an opportunity for board members to disclose anything they need to disclose or to recuse themselves if anyone needs to recuse himself or herself. More about that in just a moment. Another part of the quasi-judicial process That isn't the case in, say, legislative decision-making, where we're deciding what the rules should be. In quasi-judicial decision-making, we have to swear in witnesses. Some boards like to do this all at once, have everyone who wants to testify stand up and raise their right hand and swear to tell the truth, etc. Some jurisdictions prefer to do it when each witness comes up. Either way is valid, but those are the two ways that I've most commonly seen swearing in of witnesses in the state of North Carolina. All right. So digging deeper into that first phase and the opportunity for disclosure and recusal. Usually when we're talking about a board member making a quasi-judicial decision and disclosing something, they're going to disclose ex parte communications or that they've made a visit to the site. And we'll talk about the conflicts of interest that make it so a board member has to recuse himself or herself from making the decision. First, ex parte evidence. This is taking in evidence when not all of the parties are present. Generally, we want to try to avoid taking in ex parte evidence or talking to folks outside of the hearing about the substance of the hearing. Those ex parte communications, again, should be avoided, but have to be disclosed at some point during the hearing. That's why we often make a little time for them at the beginning, but it can be at any time. Now, it's important to note that ex parte communications, when we have to disclose, that's when there's some sort of substantive communication between the board member and either staff or a member of the public about the substance of the case. If I run into someone in the line at the grocery store and I'm a Board of Adjustment member and they ask me what time this controversial variance is going to be heard by the Board of Adjustment, or I talk to staff about whether a particular special use permit case is on our agenda for this meeting or the next, those don't need to be disclosed. You can have as many communications as you want about the kind of logistics and the context of the proceeding. Where we get into trouble is when there's communication about that is relevant to the standards that we're applying, right? When it's about the substance of the case, that's when we have an ex parte communication that should be disclosed and that a board member should not rely on when making their decision. I want to talk a little bit in particular about site visits. Some board members, individually or in groups, like to go and drive by or walk by the site of a property that is the subject of some quasi-judicial proposal. Those are fine, but they are also ex parte, right? You're looking at some of the facts of the situation outside of the hearing, so those need to be disclosed. I want to mention something else about site visits. If your board does go for a site visit, they need to do it either singly or with less than a majority of the board. Because anytime you have the majority of the members of a public body getting together to do some public business, that needs to be an official meeting under North Carolina open meetings law. So those site visits are okay, but we have to disclose and we have to make sure that we're not violating the open meetings laws when doing so. So that's ex parte evidence. That's the disclosure part. Now let's talk about the conflicts of interest, recusal. When does someone need to recuse himself or herself from a quasi-judicial proceeding? First, I want to mention what we mean by recusal. Certainly someone who is recused from a case can't vote on it, can't deliberate on it, shouldn't be asking witnesses questions. Basically, it needs to be as though that board member doesn't exist, sort of phase out. Some boards will even require their board members who are recused to leave the council table or wherever the board is gathered. That's not necessary, but the effect should be substantially similar. If I've recused myself from a particular case, then I need to take no part in it. That way we help make sure that the board is acting as an impartial decision maker. So what kind of conflicts create conflicts of interest that require this drastic step of recusal? There are three kinds that are described in the state statutes. Again, this is going to be a baseline. So your ordinances or your board procedures might have some additional requirements. Here are the kinds of conflicts. One, a financial conflict. If the outcome of a quasi-judicial case would have a direct, substantial, and readily identifiable financial impact on a member of the board, that member of the board has a conflict of interest and they need to recuse themselves. Now, of course, this needs to be something that is fairly certain and a direct financial impact, right? If I have a contract in hand to lay concrete for a proposed hotel that's the subject of a special use permit hearing before me, I have a financial conflict and I need to recuse myself. If I have a retirement account that invests in a mutual fund that invests in a real estate, blah, 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 and there's a bunch of steps, or it's not clear that I would financially gain from the project, then we don't need to worry about it. The second category of conflicts deal with relationships. If a board member has a close family, business, or associational relationship with basically one of the folks who have standing, then that board member needs to recuse himself or herself. Interestingly enough, this close family relationship is in fact defined in the statutes. It's roughly a nuclear family. You have, if the relationships are grandparent, parent, spouse, sibling, child, or grandchild. And that applies whether those are blood, in-law, half, or step relations. So at a minimum, and again, this is kind of the state baseline, I can't hear a variance case that my brother submits or my brother-in-law. The business relationship doesn't have to be connected to the special use permit. I might want to approve my business partner's special use permit, even though our special use permit is, even though the special use permit doesn't relate to our business together, we've got that relationship where one might start to wonder, is this board member making their decision based on the relationship instead of making the decision based on the evidence? That's when we have that's when if there's a situation that's on the borderline, someone should recuse themselves. If there's a substantial chance that someone from outside would be concerned that a decision is being made on the basis of a relationship instead of the facts, then we need to consider having someone recuse himself or herself. Now, this associational category that hasn't really been defined by statute, regulation, or case law, so that's really up to the good judgment of the board and the good and reasonable judgment. So that's where this kind of touchstone of would someone be afraid that it's that the decision is being made based on the relationship. The other kind is kind of bias or perspective. So if a board member has undisclosed ex parte communications or is biased, I'm about to talk about that, then that board member should not be participating in the quasi-judicial case. And what we mean by bias is not that there's kind of a predilection to vote for or against. This is if someone has made up their mind. You have a fixed position that you are not going to change before the hearing, then you're biased and you need to remove yourself from that quasi-judicial case. Now, this neutrality conflict is probably going to be brought up most often on appeal, but that's when they apply. If there's undisclosed ex parte communications, or someone has already made up their mind before the hearing. It may be that I'm not particularly inclined to vote for Ken's proposed variance, but I'm going to look at all the facts and make my decision then. Then I'm fine. I don't have a conflict there. It's only if we've made up our minds in advance. Again, your board may have procedures, or your local government may have rules that build on this baseline, but this is the state law baseline that applies regardless of where you are. Now you might be thinking, what if there's a conflict about the conflict? What if not everyone agrees that a particular person should be recused? Then the board can discuss that potential recusal. And the board then can even vote by majority vote whether someone needs to be recused or not. So there can be some discussion and vote if that's appropriate, if that needs to happen, to determine whether there's need for someone to recuse himself or herself from a quasi-judicial hearing. All right, now let's move on to the presentation of evidence. We got our notice, we've got our hearing, we've done some work of figuring out if there's a reason why anyone needs to disclose something or not participate in the case. Now let's get to the hearing itself and the presentation of evidence and making the decision. I'll note there is another module on deciding quasi-judicial cases that discusses the evidence and this deliberation in a little more detail. First of all, what kind of evidence is presented? Some of it will be witness testimony, and some of it will be in the form of documents. Now, for testimony to be, we call it competent, material, and substantial. For evidence to be the basis of a quasi-judicial decision, that evidence needs to be competent. In other words, someone needs to know firsthand, have facts in front of them. That testimony needs to be material. It needs to relate to the standards and the land use impacts of what we're looking at. And it needs to be substantial. Now that means, we don't mean substantial in terms of there has to be a lot of it. Really, we mean substantial in that there's some substance to it. So that can come in the form of firsthand testimony, speaking from firsthand experience. I'll note that if we're talking about something that's going to happen in the future, right? We're giving an opinion about what might happen if a particular project is approved. That's an opinion. And there, for that testimony to be competent evidence, we need to have an expert provide that opinion. So when we looked at clear guiding standards, recall that one of those related to not injuring the value of surrounding property. There, the applicant is probably going to need to have an expert, an appraiser, come in and say something about how the proposed project would affect surrounding property values. They need to have kind of done their homework to prepare for giving that opinion. The other kind of evidence comes in the form of documents. That starts with the application and other documents that might have been submitted before the hearing. It also might come in the form of things that are passed up at the hearing. So any of this testimony or documentation can be the source of evidence that the board is going to base their quasi-judicial decision on. So let's talk about the process of making that decision. That decision has to happen in an open session before the public. There's no going into closed sessions if it's particularly sensitive. There are reasons why North Carolina boards can go into closed session, but those are very limited. And most of those, if not all of them, will not apply to making a quasi-judicial decision. So we've got to have our deliberation in open session, and it should focus on the evidence that's been presented and how that evidence matches up with the standards that are in our ordinance, or in the case of variances, the standards that are in state law. When making that deliberation, the board's decision can be to approve the application, to deny it, or to approve it with conditions. But if we approve with conditions, those conditions have to relate to the standards that we're applying and the land use impacts of the proposal. When it comes time to vote, we need a 4/5 majority to grant a variance. Only a simple majority will do for other quasi-judicial decisions. And once that decision is made, it needs to be reduced to writing. We need to have a final written decision that includes findings of fact and applies the board's reasoning of how those facts lead us to finding that the standards in our ordinance or the standards that we're applying in the quasi-judicial case are met. So that's the final decision. Approve with conditions that relate to the standards and land use impacts, or deny. When we reduce that to a final written decision, that is a key part of what a court looks at if there is an appeal. Now, for most quasi-judicial decisions, the appeal goes to Superior Court. That's your local county court. It's called a petition for a writ of certiorari, which is a fancy legal term that relates to some fancy legal technicalities, but it's an appeal. Effectively, you're appealing to Superior Court to challenge a Board of Adjustment decision. Courts will look through the record. They'll look for various kinds of legal issues, exceeding authority, for instance, in applying some conditions. They'll also look to make sure that the decision that was made is backed up by some competent material and substantial evidence. Now, when the Superior Court does this, they don't have a whole new factual hearing. That appeal is based on the record that has been put together by the local government. So that becomes the basis of the appeal. So now we've gone through clear guiding standards, notice, an opportunity to be heard, some steps we can take to make sure we have an impartial decision maker, making our decision based on evidence, and a right to appeal. That's the quasi-judicial process in a nutshell. Again, I'm Jim Joyce. Thank you for watching.
What's going on over here? Is there a quiz?
Gotta watch the next one first. No. Y'all, are there any questions or anything y'all want to discuss about that video before we move on to the next one?
I have a question. Do you know what they're putting in where the Farm Bureau was?
Was that in their video? It is going to be, they have applied for permits. They have not been issued yet, but that is Outer Banks Hospital Internal Medicine. They're going to remodel that space
Wow.
for an internal medicine office.
Oh, wow. Okay.
If there are no other questions or anything y'all want to discuss about that video, we're going to move on to the next one, which is titled Deciding Quasi-Judicial, or no, excuse me, this is the quasi judicial cases and decisions.
Wes, I do have a question. What's your understanding?
And I should have said I'm not a UNC
Sure.
school of government expert, but I can try to answer questions as you can too.
You know, when we're not the decision maker in a quasi judicial process, like a use permit, what of that do you think is more applicable to, our meetings when we're considering those types of recommendations?
So if you recall, we recently amended our ordinance to go by what the statute 160D says with respect to special use permits, and it's very specific in the statute.
Yeah.
I'm trying to get to the exact language, but that would not, when the planning board considers a special use permit application, you all are not the decision maker. Y'all do not hold the quasi judicial hearing for it. You all are acting as, just like in a zoning text amendment, that's a legislative process, but you all are recommending, you're making a recommendation to the town council, who would then, they will hold a quasi judicial hearing. But that's a good question. And just as an example, we'll go to the special use permit section of our ordinance. Let's see. So when a written application for a special use permit shall be submitted to the Planning Code Enforcement Department. The application shall include listed names of abutting property owners. The town planning board shall provide a preliminary review for a special use permit application. The board shall submit the findings of the review to town staff. Then the town council will hold the evidentiary hearing. And then the planning board duties, I think that's where it addresses powers and duties. Where is it? To provide a preliminary forum for review of special use permit applications, provided that no part of the forum or recommendation may be used as a basis for town council decisions. And I remember we talked about that some.
But that came from the legislature.
It did. That came right from 160D. And,
Refresh my memory without looking back in there. And I was surprised that James Joyce didn't go over a little bit of this, is the power of the subpoena, because that was something we were considering possibly using in a past quasi judicial situation.
right. Our ordinance does touch on subpoena.
I think that the planning board, as providing the evidentiary part, would have, or maybe it's the parties have the ability to subpoena witnesses.
Yes, the board does have that ability.
Yeah,
Yes, I do recall. I can't put my finger on it in the ordinance at the
I
moment.
think we were considering possibly having Robert Tankard might have been.
Here it is. The board, through the chair or in the chair's absence, anyone acting as chair may subpoena witnesses and compel the production of evidence.
But is that only sitting as the Board of Adjustment?
This is only when you all are sitting as Board of Adjustment. That's correct.
I guess back to the original under the use permit though, we're not in a position of needing to determine who has standing necessarily, who has, what is competent evidence. I mean, we should, but we don't have to worry about that so much.
That's my understanding, is that when you all consider a special use permit application, you don't have to go through the conflict of interest or the ex parte communication, Yes, I think you're correct.
Yeah.
I agree.
Yeah, in essence, it kind of gutted what the planning board, acting as a board of adjustment, traditionally had done with special use permits.
Yeah, and if we go back to, let's just say 2018, what the code said then, about in the powers and duties, before that specific special use permit duty language was added to 160D. I forget what it said. Let's go to it, but. To determine whether specific proposed developments referred to it by governmental or private agencies in the area conform to the principles and requirements of the comprehensive land use plan for the area and to make recommendations concerning them. So that was much broader at that point. Anything else before we go on to the next one?
I think we're good.
Hi, I'm Jim Joyce with the UNC School of Government. My area of focus is land use and local government jurisdiction, which includes deciding quasi-judicial cases. And that's what we're going to talk about in this module. So this is the touchstone for deciding quasi-judicial cases. This quote is in the statutes, General Statute 160D 406J, and it gets repeated whenever there is a case before the North Carolina Supreme Court or the North Carolina Court of Appeals about quasi-judicial decision-making. And as you can see, that is that every quasi-judicial decision must be based on competent, material, and substantial evidence in the record. And when we talk about deciding quasi-judicial cases, that's what we mean. We're talking about how we look at that competent, material, and substantial evidence in the record and the need to focus on that and not other potential concerns. So what do we mean by competent, material, and substantial evidence? Well, we have a recent decision from the North Carolina Court of Appeals that describes in a little more detail what we mean by competent, material, and substantial. Competent evidence is relevant and admissible. It's reliable. And you have someone who is testifying from firsthand experience, for example. Or if we're talking about if someone is presenting an opinion, they're an expert. That's competence. Material evidence is evidence that has some connection with the facts of the case and the issues presented. It is relevant to the decision that we're making and to the standards that we have to apply. Lastly, substantial evidence. The language of the case is that it consists of more than a mere scintilla and such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. Well, put it differently, substantial evidence doesn't mean piles and piles of uber convincing evidence. Substantial evidence means that the evidence that's presented has some substance to it. It tends to make it more likely that someone could find one way or the other in a quasi-judicial case. So competent, material, and substantial evidence is what we're looking for in the quasi-judicial hearing, and that's what needs to be the basis for the board's decision. Now, let's talk a little bit about witness testimony. Witnesses should be sworn. This may be done as individual witnesses come up. Some boards will even swear in everyone who wants to testify on a case at the beginning of the case. One way or another, however you do it, the witness has to be sworn in. And they have to be testifying to factual information, something that is supported by their firsthand knowledge or document evidence. And it needs to be focused on the standards that are being applied and the land use impacts of whatever is being proposed as part of the quasi-judicial decision. Very important to stay focused on those standards and the land use, and not the owner, the applicant, tenants, future residents, someone who's involved otherwise with the project. A special use permit or a variance, any other quasi-judicial decision relates to a particular land use, this use on this property. The character of the owner or the history of the applicant, those aren't about the land use on the particular property. And so those are not to be part of, those are not statements that can be part of what the board uses as the basis for its decision. We can't stop anyone from providing different testimony, but the testimony that the board relies on needs to be factual and focused on the standards to be applied and the land use impacts of the proposed use. In addition, if we have someone who is presenting an opinion, as I mentioned a moment ago, if we're talking about something that will happen in the future, that opinion needs to be given by an expert. This is different from legislative decision-making. When we have a text amendment or a rezoning, in that context, people might talk about what they think is going to happen. But in a quasi-judicial decision, and that may have limited value in a legislative decision anyway, but in a quasi-judicial decision, if I'm going to testify about what's going to happen with, say, traffic, property values, or other kind of technical matters, we need that opinion to come from an expert. Here's an important distinction. I can testify to what traffic is like on my street on an average day. I live there. I see cars going by. I may or may not be able to give, I probably won't be able to give an accurate count, but I can give a general idea. I have I have firsthand knowledge of those facts, but I'm not a traffic engineer. And so I can't present my opinion about what's going to happen to traffic on my street if some quasi-judicial decision is made that allows a particular use, say in my neighborhood or next to it. That opinion has to come from an expert. One note about testimony. Boards can limit the amount of time that an individual might testify. Usually, it's okay to give a little more time to the applicant because they are the one who has the burden of proof, as we'll talk about shortly. But reasonable limits, fairly applied, can be put on the length of someone's testimony. It's often helpful to, maybe at the beginning of a quasi-judicial hearing, to remind the public that in a quasi-judicial case, we need facts. For those of you who are of my generation or before, we're like Joe Friday. We need you to give us just the facts, unless you're an expert. So that's witness testimony. Again, it has to be focused on the standards and the land use impacts as well. The other kind of testimony, the other kind of evidence that we may have in a quasi-judicial case is document evidence. This includes the application, staff reports, responses to requests for additional information, any documents that were submitted and distributed before the hearing, or documents that are presented at the hearing. I might have my 8x10 color glossy photos with circles and arrows and a paragraph on the back of each one that I pass up to members of the Board of Adjustment at the hearing. That's also document evidence that needs to be part of the record. So there you have it, testimony and document evidence. Important to note that we also have to make any objections at the hearing. So if there's a party who wants to object to a particular piece of evidence, that objection needs to be made at the hearing. All right. So we've gotten all the evidence. We've collected competent material and substantial evidence. We've gotten firsthand knowledge. We have some expert opinion, perhaps. All of the documents that came forward in the case, whether before the hearing or during the hearing. Now it's time for the board to deliberate. And the board needs to do that in open session, even if it's uncomfortable. In North Carolina, we put a strong emphasis on government transparency, especially at the local level. And so deliberation about a particular quasi-judicial decision needs to happen while we're still in open session. There are only a few situations in which a board can go into a closed session, and those are almost never going to arise in a quasi-judicial case. The board also needs to be focusing on, just like the evidence, they need to be focused on the standards that are being applied in the quasi-judicial case. These are either the standards that are present in an ordinance relating to special use, or they might be focusing on the 4 criteria that are in state law for granting a variance. In either case, we're focusing on the evidence and how that matches up with the standards. So in that deliberation, how do we decide who to vote for? Well, there are some clear rules about the burden of proof in a quasi-judicial case. And I like to think of it in terms of the scales of justice. You always have justice holding up this scale. At the beginning of the hearing, the scales of justice are tipped away from the applicant. The applicant has the first burden of proof. They need to provide competent, material, and substantial evidence that would tend to show that their application for special use permit, variance, what have you, meets the criteria that are being applied. In legal terms, we call this making your prima facie case. If an applicant does not make their prima facie case, scales of justice remain tipped away from them and they don't get whatever it was that they're applying for. However, if the applicant provides, or someone on their behalf provides competent, material, and substantial evidence that tends to support a finding that all of the standards to be applied are met, then the scales of justice tip the other way. If the applicant is the only party or the only person that presents competent, material, and substantial evidence, or if all the competent, material, and substantial evidence supports the applicant, then they are entitled to whatever quasi-judicial approval they were looking for. The board actually doesn't have the authority to deny a quasi-judicial application when the applicant has met their burden of proof, but there's no competent, material, and substantial evidence going the other way. So once the applicant makes their prima facie case, the scales of justice tip in their favor. If the opponents of whatever project is being considered, if the opponents of that special use approval then provide their own competent, material, and substantial evidence, well, now it's for the board to weigh the evidence and decide based on these contested facts, who has the better argument or who has the better evidence. So it's that scales of justice starting out opposed to the applicant. Then they make their case and the scales of justice tip in their favor. And then when we put some more competent material and substantial evidence on the other side, now it's up to the board to weigh that evidence. In doing so, the board will then make a final decision to approve, deny, or approve the application with conditions. If the board does approve a quasi-judicial application with conditions, those conditions should relate to the standards that are being applied and to the land use impacts of the proposed use. As you can see, for most quasi-judicial decisions, the board need only decide by a simple majority. If you have 5 members on the board, you just need 3 of them for a special use permit, an appeal of an administrative decision. But for variances and variances only, we need a 4/5 majority. So we've gotten our evidence. The board has considered it. They've deliberated. They've applied the appropriate burden of proof and voted to approve with conditions, or deny the application. Now it's time to reduce that decision to writing. There are different ways that one can do this in terms of the precise mechanics. But what we need to end up with is a document that describes the board's findings of fact, how they applied the facts to their standards, and that describes any conditions that might have been put on an approval. It needs to accurately reflect the decision, the final action that the board took, and the reasoning that got them there. It also needs to be approved by the board and signed by the chair or another authorized member. Now, as I said, there are different ways to produce this written record. Some local governments might have forms or drafts that then are commented on and filled in by the board during the meeting. Others might just put something together after the meeting. Some boards even have, in a separate meeting, a vote to approve the written decision. That's not necessarily required by the letter of the law. But as long as you've got that accurate record of what the facts were, how the board used those facts to get to their conclusion, and it's approved by the board and signed by the chair, then we have a solid quasi-judicial written decision. Now, why is that decision important? Part of the reason why it's important to have a good written decision is that parties withstanding who are aggrieved have a right to an appeal quasi-judicial decisions. Most of those appeals are going to go to superior court, right? They go to regular trial court. And when it gets there, the court does not have its own evidentiary or factual hearing. It sits like an appellate court. In the Court of Appeals and the Supreme Court, we don't call witnesses and testify and have dramatic courtroom moments. It's 2 lawyers arguing their case. And so when a court is looking at a quasi-judicial decision, what they have to go on is the written record. They're going to look at that record for potential errors in applying the law, like violations of the Constitution, things like conditions that might exceed a local government's statutory authority, something that's inconsistent with applicable procedures that are in the statutes or their ordinance, and other legal errors in the decision. Now there, the court can second guess the board and kind of substitute their judgment. But courts also might review a quasi-judicial decision that has been appealed on the basis of whether there is support in the form of competent material and substantial evidence in the record for the decision the board has made. And if that decision is not supported by competent material and substantial evidence in the record, it might be what we call arbitrary and capricious. That's when we just kind of pick a result out of a hat, basically. So it's important to have a good evidentiary record from your quasi-judicial decisions so that when and if a quasi-judicial decision is challenged and goes to Superior Court, there's a record that accurately reflects the evidence that was provided and the reasoning that got the board to where they ended up. Now, talking about appeals, who has standing to appeal? Not everyone can appeal a quasi-judicial decision. A person has to have standing. They have to have a certain kind of stake in the final decision. Usually that means the property owner, right, of the property that's the subject of the quasi-judicial approval application, or the applicant. Those folks, if they don't get the result they want, and they feel that there's been some sort of error of law, or the board made a decision that wasn't grounded in the evidence, then they can appeal that to Superior Court. Fun fact, a governing board, that's your city council, your board of county commissioners, your board of village aldermen, that governing board of the elected officials can appeal a decision made by their own board of adjustment. It does happen sometimes. So the governing board is another party that has standing. And finally, other property owners who will suffer special damages. That's what the law calls it, suffering special damages. Now, people who suffer special damages are in a very narrow category. Most property owners, even those whose property might go down in value or who might be right next door to the property in question, they're not necessarily going to meet this criterion of suffering special damages. Special damages means it's unique to the property. For example, my house is on a hill and there's another property owner across the street and below me. If I were to apply for a special use permit to turn my house into a much bigger building, then for the most part, people around me, even in my neighborhood, are not going to suffer special damages. But if I'm going to be impacting stormwater flows and I'm going to be, say, trash is going to trickle down onto my downhill neighbor's property, then they're in a unique situation. And that means they would suffer special damages, so they would have standing to appeal a quasi-judicial decision in my favor. So it really has to be a unique situation for someone to be suffering special damages. All right. A couple of notes wrapping up on compiling the record. Again, that consists of the application, the supporting materials, the record of the hearing itself. Now, usually you'll have an audio or video recording of the hearing. If not, then we need to have detailed minutes of the hearing, detailed enough that a court reviewing the record can follow kind of what evidence was presented to the board and how they reacted to that evidence. And of course, any other documents that get submitted, that also becomes part of the record on appeal. And so then, again, a court reviewing that quasi-judicial decision is going to be looking at the evidence. Was there enough competent material and substantial evidence in the record? And what was the board thinking when they were trying to apply this evidence to the standards that are in the ordinance or in state law? So that is how we decide a quasi-judicial case. It all comes down to competent, material, and substantial evidence in the record. And it's important to have a good record. It's important to have a good written decision at the end of the process. Thank you for watching.
All right, do y'all have any comments, questions about any of that information? A lot of the information that was touched on is in our town code and the zoning ordinance. Not necessarily broken down that way, explained that way, but the requirements and standards and some of the procedure is in our zoning ordinance. It's Article 12, Board of Adjustment. It's in town code, is online. So, and obviously if and when we ever have a case, a quasi judicial case, we town staff will bring to your attention what needs to be followed. And, in some cases, you all will have the board attorney assisting you all, if you recall. In some cases, staff will have an attorney as well, representing staff. But a lot of the things he touched on are in the ordinance, but he kind of expands on it a little bit and kind of explains it a little bit more and gives a little bit of background information. But
What was the date on those two?
that was in, I think it said May, it was either May or June 2025, but the website these came from, where they were purchased from, said that they are valid until I think the end of June this year.
Of 26?
Mhm. And I think they're putting together some new ones over the next 2 or 3 months as well on different. I saw an email from them, I think it was yesterday, that they're doing some more legislative, like rezoning and text amendment videos, which y'all have seen before, but I can't think of any statutory changes at the moment that would have changed that process for y'all. But we'll keep our eye out for new educational material for sure. But anyway, I hope this was kind of a refresher. Gives you something to think about. And if there are any questions, go ahead.
What's his face from over there on Dogwood Trail? The guy that wouldn't go away. How did his court appeal go? Did they just knock him down, or was there something that we could have done to expedite it?
The variance application that you all considered for 75 East Dogwood Trail, that appeal of your decision has not been heard in court yet. It has been continued 2 or 3 times. It will actually be heard in March, on March 16th in Dare County Superior Court.
Wow. So what's going to happen there? Is that anybody going to be there, or is it going to be already decided?
The town will be represented by the town attorney.
The continuance was requested by the applicant or by others?
From what I understand, I'm not the town attorney, but it was scheduled, I think, 2 other dates in Gates County. One of them was in Gates County. And it was, I'm not sure, I don't recall the reasons, but for whatever reason, it was not heard in Gates County and it was moved to Dare County.
Where's Gates County?
It's near Chowan County. It's just north of Chowan County, between Virginia and Chowan County.
Okay, but why would a hearing be scheduled in a court up there?
I think,
Superior
again,
Court is specific to Dare County, right?
I can't get into specifics. I'm not an attorney.
I see.
I can just explain, I can just
All
say
right.
that I
The
think
facts as they are, sure. Okay, just curious.
it was scheduled and there was a hearing date in Gates County and it was moved to Dare County.
Wasn't there a conflict?
There were, I
Interest
think
with
the
the judge.
reason, again, and this is just my opinion, I'm not an attorney, but I believe that there were concerns about conflicts,
Change of venue?
something like that, I think, yeah.
Yeah.
But again, that's just my opinion.
Okay.
Anybody have any more questions about what we saw tonight? Can we watch these online? If
They're,
we wanna-
they're only available, I think, through the end of June, and then
Oh,
they're,
okay.
then they're removed.
Yeah,
I
okay.
won't, even though we purchased it, we won't even have access to it anymore.
Okay.
But if you want to watch it between now and June, y'all can watch it as many times as you want between now
I
and
think
then.
one time's enough for me.
There's duplication.
Yeah, there is. Hopefully we got a discount on the second one because he used a lot of the material.
Some of it did overlap. There
Yeah.
was some overlap there.
Oh.
Exactly.
I spent 3 years on the Federal Green
Listen,
Jury. It's
ooh,
brought
gee.
back
Yeah,
a
right.
lot of old verbiage.
Okay, then, public comment. No one here for that. So we'll move on to planning board member comments. Natalie, I'll start with you and come back this way. Got anything?
Nothing to think of.
All right, Charlie,
No, thank you.
Michael?
Not at this time.
All right, Jane?
Can I ask Michael about your presentation and the next step?
Yeah, why don't you speak to that?
Oh, yeah,
Michael?
that'd be interesting.
Yeah, so we presented at a joint meeting, members of the planning board, members of town council, presented basically phase one of the report, which is online. Essentially, it's kind of the information gathering stage, and we really wanted to make sure that the conclusions that we arrived at, that people agreed with those, and I think generally that's what we heard. I think we've been asked to do another presentation in March, Wes, to the Civic Association, maybe.
Boat club, I think.
Yeah, the boat club.
Slow down, probably.
But again, yeah, it was really presenting, the results of the kind of our initial information collection, interviews with stakeholders, commercial property owners principally, the survey and the conclusions that we took from that, and really, the goals that we had set and kind of reevaluating those goals based on the information that we received. So if you've not looked at it, I would encourage you to look at the report. The majority of it is certainly survey results as the appendix to it, but there are a lot of interesting responses, I'd say. And the next phase, we actually have a meeting next week to talk about the last part of it, which is really the last chapter, which is implementation, coming up with actual recommended steps or actions to kind of implement the goals and objectives.
Would that then be to reach out to maybe Kitty Hawk to help?
Yeah, I think there's a lot of low-hanging fruit that we've talked about, certainly reaching out to Kitty Hawk and Dare County, VDOT, but coming up with concrete actions that we would include in a matrix, I would assume prioritized in terms of things that we could do initially, things that may cost money. So short, mid, and long term. Yeah.
Yeah, I thought it was a great start for, worthwhile project. It's got a few more pieces, I'm sure,
Yep.
in the future, but good attendance, I thought, and well done.
Yeah. Well
Thank you.
presented.
Yeah.
Good.
I
Thank you.
still like that art.
Yeah, maybe there's a opportunity for that.
Yeah.
I don't have anything. Ed,
Nope.
announcements, Wes?
Yes, sir. The next regular meeting date on your schedule is March 16th at 5 o'clock. If that meeting date needs to be adjusted, I'll reach out to y'all ahead of time.
Okay. Well, the last one's adjourning, and I will move that we adjourn this meeting.
I second it.
Jan seconds. Any discussion? All in favor? Aye.
Ah.
Opposed, none?
Had the opportunity opportunity to talk with.
Meeting adjourned. Thank you all.
Town council.